Well, guys, how you doing this afternoon? Doing a little video today on Flip Classroom on steps in our jury process. As you all know, we will be starting our mock trial next week. Is when you'll get the opportunity to interview the witnesses. You'll get your assigned roles. On Friday this week, what we will have is I'll give you your introduction packets. But for today, we actually have to cover a couple steps before we start even getting that far into the process itself. So the first thing is, what are the steps in the jury process, jury trial process? So that's what we're going to cover. As always, when we do these flip videos, please make sure you have some paper to take some notes, because you'll need these notes to ensure that you do the process correctly and travel through the whole process with as much ease as possible. So basically, what the process looks like. I've already selected some jurors for this trial. So in that, we will not have the traditional jury selection process, but I do want to go over that as well too. Let me just turn this music off here for a second. So as we go through the jury process, I do want to let you know that how the jury is selected. The first thing that happens is a court, wherever the trial is going to be proceeding, whatever court's going to be proceeding over it, there's actually a master list. That master list lists every person who's eligible to sit on trial for the jury. So you have that master list. From that, there's actually something called the veneer. There's a certain group that is selected to be possible candidates for the trial. From that, there's actually voir dire, which is a questioning statements that are questions that are sent out to the individual jurors. And from that, during this, you'll see here actually the district attorney and the defense attorneys have an opportunity to remove some of those jurors. And the first way that they could remove a juror is removing a juror with cause. So when you remove someone with cause, you actually have to have a legally sound and justifiable reason to actually remove them. So it's easy to say legally sound, but what could be? Think about what do you think could have one of those reasons? What could be one of those reasons? I will give you two examples that I've come up with. If someone was mentally incompetent, that they weren't able to sit on the jury because of a low IQ, that might be something that's important. Another one could possibly be the inability to understand written language or verbal communication. So they could actually use those two things to remove someone with cause. That could either be done by the prosecutor or the defense. The second type we have is a preemptory challenge, which is it's really they're just being removed for some sort of a subjective reason. But with that, you also have to know that you cannot be removed based on race, religion, or gender as well too, which makes me think of one of the important Supreme Court cases that we covered this year, which was the Bratson versus Kentucky, which happened in 1986. That was a Supreme Court case that ruled that people could not be removed from jurors just solely based on their religion, on their ethnicity. So with that, if in that decision, if a person feels that, if a defendant feels that an attorney is removing people based on their color, then the defense attorney would have to prove that that was actually the initial intent. So we do have that Batson versus Kentucky in 1986. So once the jurors are finally selected, you've whittled down the potential pool, the jurors will all be sworn in. So once the jurors are sworn in, We then have the trial actually begins. This is when the first thing that usually happens is the judge makes a statement to the jury about who the defendant is, what could possibly be some of the charges that they're looking at. It's just some background information. Also gives them what their duties are as jurors, and to make sure that they are fair and open-minded and balanced as possible. So once the trial begins, there's a certain process that is followed, and it starts out with opening statements. Opening statements are always given in the same order. It is an opening statement by the prosecutor, followed by opening statement by the defense. I will tell you this, you do not have to make opening statements, but it is an opportunity for you to present your case sort of in a narrative form. So because you'll see during questions you're not going to be allowed to do that. You're just going to have to ask questions directly. All right, after opening statements are made is actually we get into the questioning portion, and it starts out with questions being asked of the prosecution witnesses. So the prosecutor will have the opportunity to call up his witnesses and ask questions. That's called direct examination. After they have finished questioning that witness, the defense will then have the opportunity to do a cross-examination. So that will go on for all of the prosecution witnesses. During each one of these steps, you'll have evidence which those individual witnesses will be able to testify to the legitimacy, the accuracy of statements that may be made. So we will go from there. So once the prosecution has their witnesses, it will be then the defense's turn to call their witnesses. So the defense will call their witnesses. They will do direct examination of their own witnesses, and just the same way the defense attorney had an opportunity to cross-examine, the prosecutor in this case will have an opportunity to cross-examine the defense witnesses. Once all witnesses have been heard, it will then be the opportunity. It will be the opportunity for both the prosecutor and the defense to make closing statements. This is where the good parts of the testimony should definitely be brought out. It's the parts or the evidence that has been submitted in court that is most deeming or puts a probable cause, takes that reasonable doubt and puts that reasonable doubt into someone's mind as to someone not committing a crime. Oh, just let me go back 1 second. Just remember too that in a trial, does the defendant himself actually have to testify in court? As a matter of fact, if you could do me a favor, what I'll check tomorrow is write a full sentence answering that question. Does a defendant have to testify in court to either protect himself or to get himself off a trial? So once again, full sentence, you can hand that in when you walk in the door. That will ensure that you've actually watched this video. So going on after closing statements have been made, what we will do is we will then go into the charge of the jury. And this is where the judge will instruct, give full instructions about the types of charges and how the laws apply. So our judge in our trial has to be well versed in what charges are actually being sought by the district attorney, by Chief Slick, as well as by Sergeant Bull. So the judge, please take the opportunity to review those indictments that are being made, the charges that are being presented, and so that you actually have the opportunity, because this is the first time the jury is actually going to hear the charges. So you're going to have to instruct them and make sure that they understand it. So make sure you give them the opportunity to ask some questions if they do have those. So once the charge has been given to the jury will then go into what's called deliberation. Usually the jury does this in private where they have the opportunity to discuss among themselves. What we're going to do for ours is we're actually going to step back all the participants in the trial. We'll move to the back of the room. We'll set up a semicircle in the room where we will, as classmates, have the opportunity to listen to what the jury does. So the jury, they'll have packets and stuff and understand how this is done. I'll give them to them as well during the prep time. But this is where the juries will be talking and discussing the major facts of the case. They will be making, trying to come up with a consensus to see if a recommendation should be made for someone to be found guilty or acquitted of a charge. So once that is done, they will then take the findings and they will present it to the judge. The lead foreman of the jury will present a piece of paper to the judge. The judge will read it, and then the foreman will stand up and actually deliver the announcement as to whether or not there is a conviction or not. So that's really the process that we're going to go through with this. I hope you've learned something out of this. Remember, you do need to have notes on this so that you have this. So if you do need to go back and review, you're more than welcome to do that. And I think we're going to have fun with this. This is a big thing for us, and it should take us like about a week and a half to do. So good luck, and we'll see you at the end of this.